By late 1724, Wild had managed to almost clear London of any criminals who worked independently. It was said that he'd also gotten rid of 5 major gangs of highwaymen and footpads, and he had London pretty much under his control. However, it was from these lofty heights we see the downfall of Jonathon Wild. Hi, and welcome back to the Historical Crimes and Criminals podcast. I'm Steve, your host. And now for the third and concluding episode of Jonathon Wild. Wild had continued to operate the thieves, and he had become extremely rich, but also perhaps with a feeling of invincibility. He had manipulated so many people, he never believed he could be brought down. And by the early 1720s, he'd found a different method by which he could dispose of the property that was not claimed by their respective proprietors. He purchased a sloop, that is, a ship, in order to transport the goods to Holland and Flanders, and gave the command of the vessel to a notorious thief named Roger Johnson. Johnson masqueraded as a respectable trader and was to be found in the Grecian coffee house on the exchange where he would do business. Ostend was the port where this vessel principally traded, but when goods were not disposed of there, Johnson navigated her to Bruges, Ghent, Brussels, and other places. And he brought home lace, wine, brandy, etc., and the commodities were landed at night, avoiding import tax. And this trade continued for about 2 years, whence 5 pieces of lace being lost, Johnson deducted the value of them from the mate's pay. And irritated by the punishment, the mate lodged an information against Johnson for running a great quantity of various kinds of illegal goods. And in consequence of this, the vessel was exchequered, Johnson cast in damages to the amount of £700, and the whole commercial enterprise ruined. And a Beach Johnson was also to be the start of the downfall for Wild, and it begun with the following event. A disagreement had for some time subsisted between Johnson and Thomas Edwards, kept a house of resort for thieves in Long Lane, concerning the division of some booty. Meeting one day in the Strand, they charged each other with a felony, and they were both taken into custody. But Wild bailed Johnson, and Edward was not prosecuted. But this angered Edwards, and no sooner recovering his liberty, he gave information against Wild, whose private warehouses were searched and a great quantity of stolen goods were found. But Wild did what Wild did, and he actually arrested Edwards, to whom he pretended the goods belonged. And Edwards was taken to the Marshalsea, but the next day procured bail. And Edwards was determined to wreak his revenge upon Johnson, and for some time he sought him, and meeting him accidentally, he gave him into custody of a peace officer who conducted him to an adjacent alehouse. Johnson sent for Wild, who immediately attended, accompanied by his man, Quilt Arnold, and Wild promoted a riot, during which time Johnson availed himself as an opportunity of effecting an escape. But this caused problems for Wild. He was accused of arranging the rescue of Johnson, and he now decided to abscond himself, and he remained hidden for 3 weeks, at the end of which time, supposing all danger to be over, he returned to his house. But when being given this news, Mr. Jones, the High Constable of Holborn Division, went to Wild's house in the Old Bailey on the 15th of September 1725 and apprehended him in Quilt Arnold. He then took them before Sir John Fryer, who committed them both to Newgate on a charge of having assisted in the escape of Johnson. On Wednesday, 24th of the same month, Wild moved to be either admitted to bail or discharged, or brought to trial that sessions. On the following Friday, a warrant of detainer was produced against him in court, and to it was fixed the following articles of information, and it really did show what a stranglehold he had on criminal London, and what a document it was. It reads as follows. 1. That for many years he had been a confederate with great numbers of highwaymen, pickpockets, housebreakers, shoplifters, and other thieves. 2. That he had formed some kind of corporation of thieves, of which he was the head or director, and that notwithstanding his pretended services in detecting and prosecuting offenders, he procured such only to be as hanged as concealing their booty or refused to share it with him. 3. That he divided the town and country into so many districts and appointed distinct gangs for each, who regularly accounted with him for their robberies, and they had a particular gang to steal at churches in times of service, and likewise other moving detachment to attend at court or birthdays, balls, at both Houses of Parliament, circuits, and country fairs. 4. That the persons employed by him were for the most part felon convicts who had been returned from transportation before the time which they were transported was expired, and he made choice of them to be his agents because they could not be legal evidence against them, and because he had in his power to take from them what was part of the stolen goods he thought fit, and otherwise use them ill, or hang them, as he pleased. 5. That he had, from time to time, supplied such convicted felons with money and clothes, and lodged with them in his own house, the better to conceal them, particularly some against whom there are now informations for counterfeiting and diminishing broad pieces and guineas. 6. That he had not only been a receiver of stolen goods, as well as of writings of all kinds for nearly 15 years past, but had frequently been a confederate and robbed along with the above-mentioned convicted felons. 7. That in order to carry on with these vile practices and to gain some credit with the ignorant multitude, he usually carried a short silver staff as a badge of authority from the government, which he used to produce when himself was concerning in robbing. 8. That he had, under his care and direction, several warehouses for receiving and concealing stolen goods, and he also had a ship for carrying off jewels, watches, and other valuable goods to Holland, where he had superannuated a thief for his factor. 9. That he kept in pay several artists to make alterations, transform watches, seals, snuff boxes, rings, and other valuable things, that they might not be known, several which he used to present to such persons as he thought might be of service to him. 10. That he seldom or never helped the owners to the notes or the papers they had lost unless he found them able to exactly specify and describe them, and then often insisted on more than half the value. 11. Appears he has often sold human blood, that is, sent innocent people to their deaths by procuring false evidence to swear persons into facts they were not guilty of, sometimes to prevent them from giving evidences against himself, and at other times for the sake of the great reward given by the government. This information of Mr. Jones was also read in court, setting forth that 2 persons could be produced to accuse the prisoner of capital offences. The men alluded to in the above affidavit were John Fullard and Thomas Butler, who had been convicted for crimes but agreed to testify against Wild in return for immunity. On Saturday, the 12th of April, Wild by counsel moved that his trial be postponed till the ensuing sessions, and an affidavit made by the prisoner was read in court. This purported that till the preceding evening he was entirely ignorant of the bill having been found against him, and he didn't know what offence he was charged with, and was unable to procure 2 material witnesses, one of them living near Brentford, and the other in Somersetshire. This was opposed by the counsel for the Crown, who urged that it would be improper to defer the trial on so frivolous a pretext as made by the prisoner, and the affidavit expressed an ignorance of what offence he was charged with, and yet declared that 2 nameless persons were material witnesses. The prisoner informed the court that his witnesses were Hayes at the Pack Horse on Turnham Green and Wilson, a clothier at Frome. He added that he'd heard it intimated that he was indicted for a felony upon a person named Streatham. Wild's counsel moved that the names of Hay and Wilson might be inserted in the affidavit, and it should again be sworn by the prisoner. Prosecution witnesses, Fullard and Butler, were bound to appear at the ensuing sessions, when it was agreed that Wild's fate should be ascertained. And during his incarceration at Newgate, the confident Wild lived in luxury, sleeping on a comfortable mattress and his own sheets. He drank his favourite brandy, and his assistants visited daily, and he attended to his normal business. In order to prove his innocence to London law and order, previous to his trial, Wild distributed amongst the appointed jurymen a great number of printed letters under the title "A List of Persons Discovered, Apprehended, and Convicted of Several Robberies on the Highway, and also for burglary, housebreaking, and also for returning from transportation by Jonathon Wild." The list contained the names of 35 for robbing on the highway, 22 for housebreaking, 10 for returning from transportation, and several others have also been convicted for like crimes, but remembering not the person's names who have been robbed, I omit the criminals' details. Pleased to observe that several others have also been convicted for shoplifting, picking of pockets, which are capital crimes, and which are too tedious to be inserted here, and the prosecutors not willing to be exposed. In regards, therefore, of the numbers above convicted, some have yet escaped justice, are endeavouring to take away the life of said Jonathon Wild. But Wild's grip of fear over London's criminal was starting to crack, and more people came forward, pressing claims to his criminal misdeeds. On Saturday, 15th of May 1725, Wild was indicted for privately stealing in the house of Catherine Streatham in the parish of St Andrew, Holborn, 50 yards of lace, the property of said Catherine, on the 22nd of January 1725. He was a second time indicted for feloniously receiving from said Catherine on the 10th of March 10 guineas on account and under pretence of restoring said lace without apprehending and prosecuting the felon who stole the property. The prisoner, being put to the bar, requested that the witness might be examined apart, which was complied with. Henry Kelly, deposed that by Wild's instructions, he went on the 22nd of January 1725 with Margaret Murphy to Stretham's shop under pretence of buying some lace. Whilst there, he stole a tin box and gave it to Murphy in order to deliver it to Wild, who had waited in the street for the purpose of receiving their booty and rescuing them should they be taken into custody, and that they returned together to Wild's house, where the box, being opened, was found to contain 11 pieces of lace that Wild said he could afford to give no more than 5 guineas, as he should not be able to get more than 10 guineas for returning the goods to the owner, and received as his share 3 guineas and a crown, and Murphy had what remained of the 5 guineas. Margaret Murphy was next sworn, and her evidence corresponded with that of the former witness. And Catherine Streatham, the elder, disposed that between 3 and 4 in the afternoon of the 22nd of January, a man and a woman came to her house pretending they wanted to purchase some lace, and she showed them 2 or 3 parcels to the quality and price of which they objected, and that about 3 minutes after they left the shop, she found missing a tin box containing a quantity of lace, the value of which she estimated at £50. The prisoner's counsel observed that it was their opinion he could not be legally convicted because the indictment positively expressed that he stole the lace in the house, whereas it had been proved in evidence that he was at a considerable distance when the fact was committed. They allowed that he might be liable to conviction as a necessary before the fact or guilty of receiving the property, knowing it to be stolen, but conceived that he could not be deemed guilty of a capital felony unless the indictment declared that he did assist, command, or hire. The court was packed, and it was a media sensation when the jury brought in their verdict, not guilty. However, Wild was indicted a second time for an offence committed during his confinement in Newgate. It was that Act of 1718 which deemed every person guilty of a capital offence who should accept a reward in consequence of restoring stolen items without prosecuting the thief. And Catherine Streatham gave the following statement: "A box of lace being stolen out of my shop on the 22nd of January. I went in the evening of the same day to the prisoner's house in order to employ him in recovering my goods, but not finding him at home, I advertised them, offering a reward of 15 guineas and saying no questions should be asked. The advertisement proved ineffectual. I therefore again went to the prisoner's home, and by his desire gave the best description of what I was able of the persons I suspected to be the robbers, and promising to make an inquiry after my property, he desired me to call again in 2 or 3 days' time. I attended him a second time, and he informed me that he had learnt something concerning my goods and expected more particular information in a short time. During this conversation, we were joined by a man who said he had reason to suspect that one Kelly, who had been tried for circulating plated shillings, was concerned in stealing the lace. And I went to the prisoner again on the day he was apprehended and informed him that although I had advertised a reward of no more than 15, I would give 20 or 25 guineas rather than not recover my property, upon which he desired me not to be in too great a hurry, and said the people who had the lace had gone out of town, but he would contrive to form a disagreement between them, by which means he should be able to recover the goods for me on easy terms. And he sent me word on the 10th of March that if I would attend him in Newgate and bring 10 guineas with me, the goods would be returned. I went to the prisoner who desired a person to call a porter, and he gave me a letter saying it was the direction he had received where I could apply for the lace. I told him I could not read and gave the letter to the man he had sent for, who appeared to be a ticket porter. The prisoner then told me I must give the porter 10 guineas, and he might pay the people who had the goods, otherwise they would not return them. I gave the money, and the man went out of prison, and in a short time he returned with a box sealed up, although it was not the box I lost. I opened it, found all my lace, excepting one piece. I asked the prisoner what satisfaction be expected, and he answered, "Not a farthing. I have not interested views in matters of this kind, but act from a principle of serving people under misfortune. I hope I shall soon be able to recover the other piece of lace, and then return you the 10 guineas, and perhaps cause the thief to be apprehended. For the service I can render you, I shall only expect your prayers. I have so many enemies, and not knowing will it be the consequence of this imprisonment." The counsel for the Crown observed that from the evidence obtained, no doubt could remain behind the prisoners being behind the criminal enterprise, even if not accepting monies, since it had been proven that he had been engaged in combinations with the felons and had not discovered them. The judge was of the opinion that the case of the prisoner clearly maintained a correspondence with felons, and as the testimony had received money for restoring goods to the owners, which money was divided between him and the felons, the jury pronounced him as guilty, and Wild was to be executed at Tyburn on Monday, the 24th of May, 1725. Wild, when he was under the sentence of death, declared that he thought the service he had rendered the public in returning the stolen goods to the owners and apprehending felons was so great as justly to entitle him to a reprieve, but this was refused. On the morning of his execution, on the 24th of May, 1725, in fear of death, he attempted suicide by drinking a large dose of laudanum, but because he was weakened by fasting, he vomited violently. And Wild's hanging was a great event. Tickets were sold out in advance for the best vantage points. The road to Tyburn and Tyburn itself drew an especially large and boisterous crowd, including Daniel Defoe, the author of Robinson Crusoe, who said the crowd was larger than anything he'd ever seen before. And Wild was accompanied by William Sperry and Robert Sanford, they were highwaymen, and Robert Harpen, a coiner. On his journey to Tyburn, Wild, still semi-conscious by the effect of the laudanum, was struck in the head by a stone, caused him to bleed. The hangman executed the 3 other convicts in turn, but the mob grew more raucous due to the perceived lack of speed to the proceedings, and they wanted to see Wild hanged and shouted threats to the hangman. And the hangman, Richard Arnott, was no fool, and he complied. And it was thus that an insensible Wild met his fate, and London's most infamous criminal finally met his end. Wild's body was buried in the churchyard of St Pancras Old Church, next to Elizabeth Mann, as he wished. But his burial was only temporary. In the 18th century, autopsies and dissections were performed on the most notorious criminals, and consequently Wild's body was exhumed. His reputed skeletal remains are now in public display in the Royal College Hunterian Museum in Lincoln Inns Field. And Wild had by the woman he married in Wolverhampton a son about 19 years old, and he came to London a short time before the execution to see his father. He subsequently emigrated to America. And afterwards it was reported by the Daily Post that Mary Brown, who had already had 2 lovers hanged in Tyburn in the past few years, was to marry shortly after the death of Wild to his assistant, Will Arnold. The legacy of Jonathon Wild is something we see repeated over generations. It's the feeling of power that causes people's downfall. They have more money than they could be spent in 5 lifetimes, but they generally can never walk away from that feeling of control, especially after all the effort of gaining it. It's the story of every mafia don, an underboss waiting to take his place by whacking his boss, or the FBI waiting to imprison you for life. But as time shows, there'll always be a new Jonathon Wild waiting in the shadows. And this is the end of this series, but I'm actually going to plough straight into the next series next week with my plan to take a break midway through the series when COVID allows us to start travelling freely. At that point, I'll be packing my bags and taking myself off somewhere nice and warm. And I would say, also, if you've not left a review, please do take a minute after this episode and leave one. It really does help boost the profile. And for the next series, I've got some exciting episodes, including the Rotherham transvestite murder, Mike Malloy, the Rasputin of New York, the Glamour Girl Slayer, the Vampire of Dusseldorf, and of course, everyone's favourite, another pubs episode. And until next week, bye bye.